I want to come in on 3 points, if I may. And if we just go back to the briefing document you provided, the updated briefing document, page 21. This is in relation to some payouts that were made to staff members as the authority is winding down. And the total amounted to 103,000 and change, and was divided between a settlement payment of 14,750 gross. Sorry, it's on the actual page 22 now. Made to a staff member in lieu of time off for working on social hours over a 5-year period. And the staff member was then awarded a payment of 88,379 gross in respective increments for the period from 2001 to 2011, which had previously been paid. So, when were those two decisions made on those two payments?
Towards the end of, I think, Deputy, it would have been around, it was a report on the 12 accounts, so probably sometime in 2012.
The decision was made to make those two payments?
Correct.
Yeah. So does that involve the individual, say, in the first instance, the one who is coming up for time off for working on social hours over a 5-year period? I mean, was it a case that over the 5 years each year they requested that money and it wasn't paid? And then eventually in 2012 they said this is a liability, now we have to cover it? Or how do you reach that determination?
First of all, Deputy, both of these were mistakes made by the authority. Sure. These are payments that should have been made, and as part of the wind up of the authority, one of the areas I specifically looked at were the HR issues surrounding the various different people in the authority. We audited the files of the various different people that were still with us in the authority. We identified these two errors. In one case, the staff member, from memory, and my memory fails me a little bit here on one of them, but in one case, the staff member had previously requested, okay, in relation to the larger payment,
this is
okay, the 88,000 one, that those payments would be made. The person in this particular example was on a scale, and the authority had not been paying the staff member the increments. And it had been raised, it is my understanding, it had been formally raised by the person under a previous regime, so maybe a couple of the chief executives back. And then the gentleman brought it to my attention sometime in probably early 2012, took legal advice on it, we reviewed the situation, discussed it with the board. And
who took the legal advice? Did he or did you?
We took the legal advice, and our conclusion was that the authority had made an error.
Okay, but he had been protesting about this lack of pay, I suppose. Or,
correct.
Yeah, over a number of years, and it hadn't been listened to.
And it hadn't been listened to.
Okay, thank you. Then the second point I wanted to raise was in relation to this issue that Deputy Nash raised. In October 2009, and the signing of this contract and the moratorium was in place, it was done by the former CEO without notifying the board, even though the board had clearly instructed him not to do it. Is that basically it?
Correct.
And that was Mr. Kelly?
We believe so.
You believe it was Mr. Kelly?
Well, I think Mr. Maloney had to part. Just looking at the dates,
yeah,
I think logically
it couldn't have been Mr. Maloney.
It couldn't have been Mr.
And so, how did Mr.
I can confirm that for you.
If you could, then what happened to that CEO as a result of such a clear breach of his responsibilities? And I don't know if it's a breach of the law or not. It's a separate matter, but
I don't know. I don't know the answer.
How long was Mr. Kelly with the authority?
In his capacity as chief executive, maybe 2 years.
2 years. And who was he replaced by?
Ms. Lampkin, who was before the committee before.
Would it be fair to say that Professor Brennan might have some information on that situation with Mr. Kelly?
Well, Professor Brennan was the chairperson at the time.
Chairperson at the time. Chairperson at the time that was discovered, or the chairperson at the time that it occurred?
Both.
Okay.
Professor Brennan, I think, took up the chair of the authority around late 2009.
Okay. And then would have been in place until John Tierney was appointed?
John Tierney was appointed, yes, in
mid-2012,
yes.
Okay. Okay. That might be something then to bring up with her at a later stage. Thank you. And so the final thing I wanted to raise, Chair, and it relates to what the CNAG brought up in his statement, opening statement. I mean, Just to put a bit of context, we had back and forth on this with Mr Maloney in a previous meeting, and we also had back and forth in meetings prior to that. And there was a difference of opinion between yourself and him as to what the board believed they were entering into. And we received, Mr Crawley, a note from you on that matter, document 3A1C. And can I just ask, because I want to get clarity on this because it's going to be important for later on, I mean, to the CNAG, do you believe that the note provided by Mr Crawley backs up what Mr Maloney was claiming?
Well, the note provided by Mr Crawley deals with what was in the shareholders' agreement. The back and forth, as you describe it, between Mr Maloney and myself was in relation to what the board authorised or directed or decided should be in the shareholders' agreement and in relation to the investment. So I've no difficulty at all with what's in Mr Crawley's note. Those are the facts, and I'm satisfied with it. Where I think the difficulty arises in what is about what did the board think they were doing or think that they were agreeing to at the time. And obviously we were, in practice, we were restricted to relying on the board minutes, which Mr Maloney and I agreed should be a comprehensive record of what was actually decided. And what I tried to outline this morning was that this is the sequence of decisions, and I think the chair has referred to the speed at which the decisions appear to be changing. But I was also trying to draw attention to the lack of clarity about what those decisions were. Even, for example, in relation to this limit of 35 million. It appears, when you look at the executive board minutes, that what they were talking about was a limit on the exposure through the guarantee. But in fact, what the limit of 35 million was on everything else except the guarantee. The guarantee had a separate scope of limitation. Effectively, the guarantee was 26% of 100 million, therefore 26 million. Plus the interest, 26% of the interest on the Beck Bay borrowing for a period of 2 years. Now, in the event that isn't the way it panned out, and by the time the authority came to do the deal with NAMA, by the end of 2010, they'd racked up a total exposure of about 86 million. Is that the figure?
I think that's correct.
Yeah, it is. Sorry, 82 million. 82 million. By the end of 2010, and there would have been further liability accrued up to July of 2011. And had a deal not been done with NAMA, that liability would have continued to increase. So there's 2 points there. The attempt to limit the exposure didn't work. And secondly, the fact that it was changing, the amount that they were agreeing to commit was changing within the space of days. Yeah. And to my mind, that is something that should be very clearly documented in minutes and very clearly understood by boards when they're making those kinds of decisions.
Mr. Maloney claimed that the board minutes for the authority were, I think, the most detailed of any state authority or semi-state body. But clearly you think that I think you said earlier, the records are ambiguous when it comes to this matter.
I think so. In particular, the minutes of the 2nd of November.
And if I could just briefly for a second, because if we go back to the exchange that you had, Mr. Maloney said this in our meeting in December, on the figure of 35 million, we all agree now that it was a funding guarantee liability to do with recourse and interest. At the time of the shareholders' agreement, the 32 million for equity was also in the shareholders' agreement. The authority knew it had the 35 million liability plus the 32 million equity. Does the Controller and Auditor General accept that? And you replied, no, I do not.
And the first point you read out was that the 35 million limit applied to the guarantee, I think. It doesn't apply to the guarantee, and that's not what's in the shareholders' agreement. It's everything other than the guarantee.
I mean, the position on that hasn't changed.
I think that it is ambiguous as to what the records actually say, and even there appear to be contradictions between the various documents, the documents themselves.
And if I take your point, Deputy O'Donnell, or perhaps you were inferring the speed at which this change, if we go by that interpretation, Mr. Maloney's, is that it might lack credibility then, that that's actually what the board would move to agree in such a short period of time. But that's obviously for the PAC to...
Well, I think if you remember, the value of the site was changing considerably. Or the recorded value of the site was changing as in between the various minutes.
Went from 350 on the 20th of October to 412 on the 24th of October. That was only in space of 4 days.
Yeah, and obviously at the beginning of October there was references to site values of 240 and 300 million. So I suppose that there is a difficulty with all of this in that the record in relation to this is not, in my view, sufficiently accurate and comprehensive for an investment of this scale. And I think that's the point we were trying to make in the report.
Thank you.